This just in, Justin Baldoni's team has issued a response in opposition to dismiss the New York Times, and there is a bit of a smoking gun.
What happens when a Hollywood star's attorney goes nuclear on America's most powerful newspaper? The answer might shock you. Justin Baldoni's legal team has just dropped a bombshell response to the New York Times motion to dismiss his defamation lawsuit, and the allegations are absolutely explosive. Let's dive into the juicy details that no one else is talking about. The New York Times thought they could hide behind journalistic privilege and escape accountability. They were dead wrong. Baldoni's powerhouse attorney Brian Friedman didn't just respond to their motion, he systematically dismantled it, calling the newspaper a pietistic bastion of the media establishment that has long presumed itself beyond accountability. Translation: your prestigious reputation won't save you this time.
A pietistic bastion of the media establishment. And by the way, pietistic means of or relating to religious devotion or devout persons. You know it's going to be a good one when we have to use the dictionary for the first word. A pietistic bastion of the media establishment. The New York Times has long presumed itself beyond accountability.
But what's truly jaw-dropping here isn't just the colorful language. It's the evidence Baldoni's team presents. They've accused the New York Times of actively colluding with Blake Lively and her team to craft a hit piece designed to destroy Baldoni's reputation. This isn't just about reporting on allegations, it's about allegedly orchestrating them.
The fair report privilege the New York Times seeks to hide behind does not protect it from liability for maliciously colluding with Lively and her cohort to publish a false and defamatory hit piece about the Wayfair parties.
The smoking gun? A video featuring New York Times journalist Megan Twohey accompanying the article. In this damning clip, Twohey doesn't simply report on Blake Lively's complaint. She explicitly states that private text messages and other documents that we've obtained reveal what really happened. She doesn't present these as allegations or claims. She presents them as verified facts.
Reveal what really happened. A campaign to tarnish Lively after she alleged that Justin Baldoni, her co-star and director, and Jamie Heath, the producer, had engaged in misconduct. Private text messages and other documents that we've obtained reveal what really happened.
This distinction is crucial because it potentially strips away the fair reporting privilege that typically protects journalists. Media outlets generally enjoy protection when reporting on legal complaints or government proceedings. But Baldoni's team argues the Times went far beyond merely reporting.
The New York Times offers its own commentary that goes well beyond merely reporting on the CRD complaint. Because if you just report on the CRD complaint, you might be okay under the fair reporting rule, the fair reporting privilege. But because they relied on those thousands of pages of other documents, therefore it falls outside the scope of the privilege.
In their own words, the newspaper admittedly based its article and video on its reporter's review of thousands of pages of documents and expressly credited Lively's claims, framing them as having been verified by the New York Times' own investigation. By doing so, they essentially vouched for claims that Baldoni insists are demonstrably false. The timeline of events described in the legal filing reads like something from a thriller. According to Baldoni's attorneys, the New York Times had been working on their article for months, possibly since October 2024. Yet they only contacted Baldoni's team the night before publication, on December 20th, giving them virtually no time to respond.
The New York Times prepared its salacious article well before Twohey contacted the Wayfair parties the night before publication for quote-unquote fact-checking. After the New York Times' months of plotting with the Lively parties.
Even worse, they allegedly promised Baldoni's team until noon the next day to provide comments, but then published at 7:11 a.m., nearly 5 hours before their own deadline. If true, this tactic wasn't just unprofessional, it was potentially part of a calculated strategy to minimize Baldoni's ability to defend himself.
Although the Wayfair parties accepted the New York Times offer and scrambled to respond in just hours, the New York Times published early and without warning at 7:11 a.m. Pacific Standard Time. The release of the false article and video damaged the Wayfair parties.
Imagine scrambling overnight during the holiday season to respond to explosive allegations, only to wake up and discover the article has already been published without your complete response. It's the journalistic equivalent of asking someone to a debate and then starting while they're still on their way to the venue.
They said, evening of December 20th, hey, Justin, here's all this horrible stuff we're going to print about you. You have until tomorrow at noon. We'd love to hear your response. He engages with them. He says, okay, here is some information. I think he gave it to them on the morning of the 21st. Here's some partial information.
But the battle isn't just about what happened. It's also about where the case should be tried and under which state's laws. This seemingly technical detail could actually determine the entire outcome of the case. Baldoni's team is fighting hard for California law to apply, while the New York Times wants New York law to govern the proceedings.
And is that California recognizes the cause of action of false light and New York does not. So there's going to be a number of different claims that are going to be different between the states. And even defamation is a little different between California and New York.
Why does this matter so much? Because California recognizes legal claims that New York doesn't, including false light, a claim similar to but distinct from defamation. California law also has different standards for what constitutes fair reporting and defamation.
In this case, California has a significant interest because nearly all of the plaintiffs are residents of California. The two corporate plaintiffs are both incorporated and or have their principal place of business in California. The plaintiffs suffered injury to their reputations in California.
Baldoni's team makes a compelling argument that California has the stronger interest in the case since nearly all plaintiffs are California residents. The alleged damage to their reputations occurred in California, and even the article itself referred to a Hollywood smear machine.
The article title refers to a Hollywood smear machine in recognition of the subject's intrinsic connection to California's entertainment industry. Hello.
Explicitly connecting the controversy to California's entertainment industry. The legal document doesn't just attack the New York Times' journalistic practices, it questions whether their reporting was malicious. To win a defamation case against a media outlet, especially when public figures are involved, you need to prove actual malice. This doesn't mean the reporter had to personally hate you. It means they either knew what they published was false or showed reckless disregard for whether it was true or false.
Point. So it's not just the New York Times failed to adequately investigate, according to Baldoni, but rather it did investigate and obtained and reviewed communications that disproved what it later published and that it edited and spliced documents to mislead viewers.
Baldoni's team isn't subtle about this accusation. They claim the New York Times did investigate and obtained and reviewed communications that disproved what it later published and that it edited and spliced documents to mislead viewers. If they can prove this allegation, it would be devastating to the Times' defense. The case also pulls back the curtain on what Baldoni's team describes as the real story, that Lively allegedly became difficult during filming, made unreasonable demands, and then faced backlash when her tacky and tone-deaf marketing plan embarrassed her and blew up in her face.
And tone-deaf marketing plan, and that embarrassed her and blew up in her face. And then the first time we see Ryan Reynolds come into the case.
According to the filing, Lively and her husband Ryan Reynolds then demanded that Baldoni's team issue a statement taking blame for Lively's bad press. When they refused, the legal document claims Lively and her team worked with the New York Times to concoct a story that would blame Lively's downfall on the Wayfair parties.
Lively and Sloan parties worked with the New York Times to concoct a story that would blame Lively's downfall on the Wayfair parties, relying heavily on deceptively spliced private text messages stolen from Abel's phone.
These aren't just petty Hollywood squabbles. They're serious allegations with potential career-ending consequences. And that's precisely why Baldoni's team argues a jury, not a judge through early dismissal, should decide what happened.
Not so fast. We want a jury to decide this. And so we have enough here to get past, as a matter of law, we have enough here to get past this being thrown out at this stage, and we want a jury to make that determination.
Yeah, let us get.
The legal response doesn't just focus on the newspaper's actions. It also raises troubling questions about where the New York Times obtained all those text messages and documents they claim to have reviewed. At one point, the filing alleges that private text messages were stolen from a phone belonging to someone on Baldoni's team by a former publicist.
According to Baldoni, they apparently didn't get a subpoena because they're claiming it was stolen.
This explosive claim, if substantiated, would add another layer of potential wrongdoing to an already controversial story. Legal experts watching the case have mixed opinions on whether Baldoni can overcome the significant protections journalists enjoy in our legal system. Some point out that suing media outlets rarely succeeds, but others note that this case presents unique circumstances that might give Baldoni a fighting chance.
I think it's extraordinarily difficult to sue a media outlet and be successful. Most of these are done just for press, like, oh, I'm suing the New York Times for all this money, and they end up getting, devastated. Here, I think he has a pathway, and even if it doesn't succeed, meaning he doesn't get to a jury or a jury says, hey, I'm going to give you $1 or something like that.
Christopher Melcher, a high-profile attorney commenting on the case, suggests it serves an important purpose. I like that he's exposing this because we hope that journalists would actually investigate completely, rather than smearing and destroying one side on partial information. The irony hasn't been lost on observers that an article titled, "We Can Bury Anyone Inside a Hollywood Smear Machine" may itself have been part of an alleged smear campaign. If Baldoni's allegations prove true, it would represent an extraordinary breach of journalistic ethics by one of America's most respected news organizations.
And the irony of the title, right, Chris? We can bury anyone inside the Hollywood smear machine. The hypocrisy that Blake and the New York Times were doing the same exact thing.
As the legal drama unfolds, the next step will be the judge's decision on whether to dismiss the case or allow it to move forward to discovery, a process that would force both sides to share evidence and potentially reveal exactly how the New York Times article came together. If the case proceeds to that stage, we might finally get answers about what really happened behind the scenes. The most fascinating aspect of this legal battle isn't just about Justin Baldoni or Blake Lively, it's about the changing landscape of media accountability in the digital age. At a time when trust in traditional media is at historic lows, this case raises profound questions about journalistic ethics, celebrity influence over reporting, and whether even the most prestigious news outlets should face consequences when they potentially cross the line. Whatever the outcome, this case serves as a reminder that in today's world, where information spreads instantly and reputations can be destroyed overnight, the responsibilities of those who control the narrative are greater than ever. And perhaps for the first time, we're seeing a celebrity fight back against not just social media attacks, but against what they perceive as weaponized journalism, with all the legal firepower they can muster.
The press has to try to get it right. When I was getting sued with these, when I was getting threatened with this $120 million defamation lawsuit last year, they were accusing me of only telling one side of the story, right? They were accusing me, oh, we're going to sue you if you're lying, and of course they haven't sued me because I wasn't.
The New York Times has built its reputation on holding the powerful accountable. Now, they find themselves on the receiving end of that same scrutiny. And as this legal battle continues, one thing is certain. The media world is watching closely because the outcome could reshape how journalism intersects with celebrity, power, and accountability for years to come. As we wait for the judge's decision, one question remains. In a case where both sides claim to be victims of a smear campaign, who will ultimately prevail? The newspaper that prides itself on uncovering the truth, or the Hollywood director who insists that truth was the first casualty in a calculated attack on his reputation? The answer may not just change these individuals' lives. It could potentially transform how we understand the relationship between media and the stories they tell about the rich and famous. If you found this breakdown helpful, please hit that like button and subscribe for more updates on high-profile legal battles and entertainment industry drama. Let me know in the comments what you think about this case. Do you think Baldoni has a chance against the New York Times? I'll see you in the next video.